told by the chair at that time that under the rules of the House, we would be guided by the Fifth Amendment, and I believe that the due process rights of Mr. President and other parties are being denied with the representations that Mrs. Starr is about to make. I'd ask the chair for his ruling.
Well, the chair overrules the gentlelady's point of order, and the witness will continue.
I thank you, Chair.
Thank you, Mr. Chairman. I had said that it was in August of 1994 that I took over the Madison Guarantee investigation from Robert Fisk. Over the ensuing years, I have essentially become independent counsel for 5 distinct investigations: for Madison, Guarantee, and Whitewater, for Foster-related matters, for the Travel Office, for the FBI files matter, and for the Lewinsky investigation, as well as for a variety of obstruction and related matters that arose out of those 5 major investigations. A very brief overview of those investigations may assist the committee in its assessment of the President's conduct. First, some statistics. The chairman noted that the investigation has resulted in the conviction of 14 individuals, including the former Associate Attorney General of the United States, Webster Hubbell, the then sitting governor of Arkansas, Jim Guy Tucker, and the Clintons' 2 business partners, Jim and Susan McDougal. We're proud not only of the cases that we have won, but of our decisions not to indict. To take one well-known example, the Senate Whitewater Committee sent our office public criminal referrals on several individuals. The committee stated in its June 21, 1996 public letter that the testimony of Susan Thomas's was particularly troubling and suggests a possible violation of law. But this office did not seek charges against her. Apart from indictments and convictions, this office has also faced an extraordinary number of legal disputes on issues of privilege, on jurisdiction, substantive criminal law, and the like. By my count, pardon me, at least 17 of our cases have been decided by the federal courts of appeals, and we have been fortunate in prevailing in all 17. One privilege case arising in our travel office investigation went to the D.C. Circuit, where we prevailed by a 2-to-1 decision, and then to the Supreme Court, where we lost by a 6-to-3 decision. We had to litigate in the courts as our investigation ran into roadblocks and hurdles that slowed us down. It is true that the administration produced a great amount of information. But unlike the prosecutors in the investigations involving Presidents Carter and Reagan, we have been forced to go to court time and time again to seek information from the executive branch and to fight a multitude of privilege claims asserted by the administration, every single one of which we have won. In sum, the office where I serve has achieved a superb record in courts of law, of significant and hard-fought convictions, of fair and wise decisions not to charge, of thorough and accurate reports on the Vincent Foster death and the Monica Lewinsky matters, of legal victories in various courts. We go to court and not on the talk show circuit. And our record shows that there is a bright line between law and politics, between courts and polls. It leaves the polls to the politicians and the spin doctors. We are officers of the court who live in the world of law. We have presented our cases in court, and with very rare exception, we have won. The center of all this, the core of our Arkansas-based investigation, was Madison Guaranty Savings and Loan. Madison was a federally insured savings and loan in Little Rock, Arkansas, run by Jim and Susan McDougall. Like many savings and loans in the 1980s, Madison was fraudulently operated. Mrs. Clinton and other lawyers at the Rose Law Firm in Little Rock performed legal work for Madison in the 1980s. Madison first received attention in March 1992 when a New York Times report raised several issues about the relationships between the Clintons and the McDougalls in connection with Madison Guaranty. Federal bank examiners examined Madison in 1992 and 1993, and the regulators sent criminal referrals to the Justice Department. And the Justice Department then launched a criminal investigation of Madison Guaranty in November 1993. In part because of the relationship of the Clintons to the McDougalls, Attorney General Reno appointed Bob Fisk in January 1994. I was appointed independent counsel in August 1994 to continue the investigation. Madison exemplified the troubled practices of savings and loans in the 1980s. The failure of the institution ultimately cost federal taxpayers approximately $65 million. Congresswoman Waters put it this way in a 1995 hearing. By any standard, Madison Guaranty was a disaster. It gambled with investments, cooked the books, and ultimately bilked the taxpayers of the United States. Madison, she went on, is a metaphor for the S&L crisis. The McDougalls' operation of Madison raised serious questions whether bank funds had been used illegally to assist business and political figures in Arkansas, such as Jim Guy Tucker, the governor-to-be, and the then governor, Governor Clinton. As to the Clintons, the question arose primarily because they were partners with the McDougalls in the Whitewater Development Company. The Whitewater Corporation initially controlled and developed approximately 230 acres of property on the White River in northern Arkansas. Given Jim McDougall's role at the center of both institutions, and given Whitewater's constant financial difficulties, there were two important questions. Were Madison funds diverted to benefit Whitewater? If so, were the Clintons either involved in or knowledgeable of that diversion of funds? Those questions were not idle speculation. In early 1994, a Little Rock judge and businessman, David Hale, pled guilty to certain unrelated federal crimes. As part of his plea, David Hale told Mr. Fisk's team that he had received money as a result of a loan from Madison in 1986. He said that his company loaned it to others as part of a scheme to help some members of the Arkansas political establishment. One loan of $300,000 went to Susan McDougall's make-believe company, which she called Master Marketing. Based on our investigation, we now know that some $50,000 of the proceeds of that loan went to benefit the Whitewater Corporation. David Hale stated that he had discussed the Susan McDougall loan with then Governor Clinton, including at a meeting in 1986 with Jim McDougall and the governor. In August 1994, when I first arrived in Little Rock and building on Mr. Fisk's work, we devised a plan. First, based on the testimony of David Hale and others, as well as documentary evidence, we would take steps, if appropriate, if the evidence warranted, to seek an indictment of Jim and Susan McDougall and others involved in what clearly appeared to be criminal transactions. If a Little Rock jury convicted the McDougalls or others, We would then obtain their testimony and determine whether they had other relevant information, including, of course, whether the McDougals possessed information that would either exonerate or incriminate the Clintons as to Madison and Whitewater matters. This approach was the time-honored and professional way to conduct an investigation. We garnered a number of guilty pleas in my first year. One was from Webster Hubbell, who had worked at the Rose Law Firm and was knowledgeable about its work with Madison, including that of Mrs. Clinton as a lawyer at the Rose Firm. In addition, Robert Palmer, a real estate appraiser, pled guilty to fraudulently doctoring Madison documents to deceive federal bank examiners. 3 other associates of McDougall pled guilty and agreed to cooperate. In August 1995, a year after I was appointed by the Special Division, a federal grand jury in Little Rock indicted Jim and Susan McDougall and the then sitting governor of Arkansas, Jim Guy Tucker. The case went to trial in March of 1996, amid charges by all 3 defendants and their allies that the case was a political witch hunt. Some predicted that an Arkansas jury would never convict the sitting governor. These expectations were heightened when when President Clinton was subpoenaed as a defense witness in Governor Tucker's trial. The president testified for the defense from the map room of the White House. During his sworn testimony, the president testified as a defense witness that he did not know about the Susan McDougall loan, nor had he ever been in a meeting with Hale and McDougall about the loan. He also testified that he had never received a loan from Madison. This was important testimony. Its truth or falsity went to the core issues of our investigation. On May 28, 1996, all 3 defendants were convicted. Jim McDougall of 18 felonies, Susan McDougall of 4 felonies, and Governor Tucker of 2 felonies. Governor Tucker announced his resignation that day. After his conviction, Jim McDougall began cooperating with our investigation. We spent many hours with him, gaining additional insights and facts. He informed our career investigators and prosecutors that David Hale was accurate. According to Jim McDougall, President Clinton had testified falsely at the McDougall-Tucker trial. Jim McDougall testified that he had been at a meeting with David Hale and Governor Clinton about the master marketing loan. And Jim McDougall testified that Governor Clinton had received a loan from Madison. Jim McDougall said on one of the first sessions with our office following his conviction that the president's trial testimony was, in his words, at variance with the truth. In late 1997...
Mr. Chairman, I have a point of order.
The gentlelady, I would appreciate it if she wouldn't interrupt, but go ahead and state your point.
Thank you very much, Mr. Chairman, and I appreciate the need for us to proceed, and I want to proceed fairly. That's all I'm asking for.
I'm sure you do.
Mr. Chairman, I have stated earlier my objections to, one, hearsay, but frankly, the direction of the testimony. Frankly, I raise again the question of germaneness with respect to representations on Whitewater, Madison Guarantee, and due process, Mr. Chairman. I think this testimony is inappropriate. There is no attempt to cover up, but I do not have before me a referral from Mr. Starr or any of his deputies on the question of Whitewater, Filegate, or Travelgate. Mr. Chairman, this testimony is not germane, and it is a denial of due process.
I thank the gentlelady. This committee hearing is being conducted pursuant to notice pursuant to House Resolution 581. That resolution directs the committee to, and I quote, investigate fully and completely whether sufficient grounds exist for the House of Representatives to exercise its constitutional power to impeach